Hello friends, with the initiative of Company Law Institute of India Private Limited, this series of income tax cases has been started. In this series today we are going to discuss the case of Trump Securities Limited versus Additional Commissioner of Income Tax. This case has been reported in 99 ITAT Tribunal, short notes page number 58. The matter has been decided by Mumbai ITAT and the date of the judgment is 14th October 2022. The facts of the case are very interesting. The assessee is a trader in shares, securities, etc. The case relates to the assessment year 2000-2001. After completing the assessment, the Additional Commissioner of Income Tax initiated the penalty on the basis of the tax audit report under section 271D and 271E, wide notice dated 15th December 2003. When this penalty was initiated, after that the penalty orders were passed in the month of July. If we see the limitation of section 275 subsection 1 clause C, that gives a limitation of 6 months from the end of the month in which the penalty notice is issued. So if we go by that limitation, these two penalty orders were time barred because the notices were issued on 15th December 2003. So the last date for passing the orders were 30th June 2004, but the penalty orders were passed on 30th July 2004. But the main point was that the assessee did not took these grounds at the time of the CIT appeal. When this matter came to the ITAT on some factual disputes, reverted the matter back to the CIT appeal, and CIT appeal then enhanced the quantum of the penalty. That's why the assessee was again into the ITAT against the penalty orders of the CIT appeal, which were enhanced substantially by the CIT appeal. So, meaning thereby that in the second round of litigation, the assessee first time took the plea of this technical ground that these penalty orders are time barred. The department was contesting that the assessee cannot take these grounds. The department vehemently opposed this additional ground and said that the assessee is in the second round of litigation, so he cannot take this ground. But on this point, the ITAT said that it is purely a technical ground, it is a legal ground, so it can be taken at any stage. So this ground was allowed. Apart from this technical ground, the assessee said that this penalty has been imposed only on the basis of the comments in the tax audit report, and that also has been misunderstood because the assessee has not made any payments in cash because of the misunderstood of reading the columns that these amounts has been accepted or repaid otherwise than by banking channel. And the second point was that these loans were taken and repaid according to some journal entries. So the assessee cited also some case laws which says that section 271D and section 271E penalty cannot be imposed for the loans accepted and repaid through the journal entries. ITAT accepted both the versions of the assessee, both on the merits and on the basis of the legal ground also. The ITAT also quoted two very important decisions of Delhi High Court on section 271D penalty and section 271E penalty. The name of the cases are Principal CIT versus Mahesh Wood Products Private Limited, and this case has been reported in 394 ITR page number 312. The second case is Principal CIT versus JKD Finless Limited, and this case has been reported in 378 ITR at page number 614. In both these cases, the court said that the limitation period of 6 months will start from the date on which the assessing officer proposes the additional commissioner for initiating the penalty. Because it is the procedure that the assessing officer makes the proposal and then goes to the additional commissioner that these loans has been accepted in the violation of section 269 ST and section 269T, and then he goes for imposing the penalty. So the date on which the assessing officer proposes to the additional commissioner, that is important, and the limitation period of 6 months should be counted from that date. So according to these decisions also, the penalty imposed by the additional commissioner of income tax in these cases are time barred. These two cases are very important in dealing with section 271D penalty and section 271E penalty, because I have seen that in most of the cases the department is very lethargic in going for these penalties, and they take their own time, due to which we can have the decision in our favor. At the end of this video, once again I am repeating the name of the case. The name of the case is Trump Securities Limited versus Additional Commissioner of Income Tax, and the case has been reported in 99 ITAT Tribunal, short notes 58. Thank you, friends.